Okay, let's go on the record on cause number DC208643 Hume versus 5-Star Global. Counsel, make your appearances.
Good afternoon, Your Honor. Julie Pettit on behalf of the plaintiffs.
Good afternoon, Your Honor. Jeff Tillotson and Enrique Ramirez on behalf of the 5-Star Global defendants.
Good afternoon, Your Honor. Katrina Ish on behalf of Southfield.
All right, we've had a discussion about a substitution for Mr. Buchanan, and the parties are going to kind of try to work that out. And so there's also a motion to compel that we need to chat about as well.
May I share screen, Your Honor?
Give me 1 second. Oops. Yes, you may.
Thank you. Hoping you can see my screen okay.
Okay.
1 second. So, Your Honor, there's two narrow issues, and I do want to point out that this motion was filed before Mr. Tillotson appeared in the case. By my count, I think Mr. Tillotson's firm is the fourth firm to represent the 5-Star Global defendants in this case, but he was not the one that was present when these issues first arose, though these issues exist, and so they need to be addressed. The first is some smoking gun memos that have not been produced, and the second are some financial documents, and I'll cover them briefly. So request for production number 8, we asked for documents regarding the termination of Mr. Holm. As you recall, Your Honor, from the Delgado trial, the termination of Mr. Holm is a very significant factor in this case. Whether or not he was terminated or whether or not he quit is a hot button issue and has significant legal ramifications depending on what Your Honor ultimately decides as to whether or not he was terminated or he was fired. In the Delgado trial, first of all, in response to this request for production number 8, the 5-Star Global defendants indicated that they had produced all non-privileged responsive documents. However, months and months after they made that response, then separately, at the time, there was separate counsel in the 5-Star Global case versus the Delgado case. So there was not similar counsel among the cases. After the 5-Star Global counsel filed this or served this response months later in the Delgado case, the counsel in that particular case produced two highly relevant documents that were front and center during the Delgado trial. The first is this one, where Mr. Delgado indicated that—
Ms. Pettit,
Yes.
Unfortunately, I can't see what you're talking about on the screen.
That's interesting.
It says give subtitles a try.
Okay.
Now it seems to be working a little better.
Interesting. Okay, so here is one of the two memos that was produced in the separate case. First is this executive summary report saying that Mr. Holm refuses to accept a role. The company can't continue to operate this way. So that's a document that was produced in a separate case, but has never and still has never been produced in this case. We know it was authored by Mr. Delgado. We know it was given to members of the board, presumably by email, not by hand delivery from what we know, but it still hasn't been produced in this case. The second memo we're referring to is this one where Mr. Delgado says that Mr. Holm will be advised that FSG Board of Directors convened a meeting and determined that he has been relieved of his duties. Again, that's a huge admission showing that he was terminated, not that he quit. This was produced in another case, but 5-Star Global still has not produced this document or any of the emails surrounding it. So for those reasons, Your Honor, we think that a forensic review that's very limited is extremely necessary in this case, because we're now 2 years into litigation, and these highly relevant documents that we now know exist haven't been produced by 5-Star Global. So of course that raises the question of, well, what other documents regarding the termination have not been produced when we know these two highly relevant documents were not produced by 5-Star Global. So for that reason, Your Honor, we have with our motion included a very limited protocol that we would ask the court to order, which is simply that a third party go in using these search terms for a very limited 4-month period when all of this transpired, and produce documents that are responsive. We think that this protocol is extremely limited given the severity of what we're dealing here with, which is known documents that the other side has failed to produce. So we would ask that Your Honor order the forensic review that's outlined in our motion and the protocol that is attached. The second issue.
Oh, sorry.
The second issue, Your Honor, are financial documents. Our theory of the case is that this was a highly profitable company that the defendants acquired assets from, and that they immediately ran the company into the ground. The reason why the 2019 5-star conference financials are critical is because it falls within this very narrow time period, because the defendant's theory, and I'm sure Mr. Tillotson will correct me if I'm wrong, but part of the defendant's theory is at least is that this has nothing to do with the way the company was managed, but rather this is because of COVID. The reason why the 2019 5-star conference is so critical is because that was pre-COVID, but after the time that my client had been ousted from the company. So we've got this extremely narrow period of time that would demonstrate how the company was doing before COVID, but after the ousting. So that's why that time period is relevant. In July of 2020, so more than a year ago, we requested monthly, quarterly, and annual financial reports from January 2019 to current. That wasn't produced. What we've been trying to get for years now is the 2019 5-star conference data, because that would either prove or disprove our theory and their theory of what happened to the company. So when they didn't respond and wouldn't produce anything with respect to that request, then I broke it down, because what I'm desperately trying to find is, was the 2019 5-star conference a financial failure or financial success? So that when Your Honor tries this case, you can know during that window of time what actually happened to the company. So what I did then was I broke down my requests from request 187 to 216, and I broke down what we know are the costs and the expenses that are incurred when you have an event like this. So I said, produce documents demonstrating this expense, going through each expense and each revenue source one by one, so that we could put them together for ourselves. No documents still have been produced. The only response that they've ever said is that they, quote, will produce the responsive documents, but to date we have none. Not only is my client a huge shareholder of the company and has been refused financial documents, but now for 2 years during litigation, we've tried to reach an agreement after agreement, and still we do not have the data that we need to show Your Honor what happened at the 2019 5-star conference, which is going to be front and center at trial. The other issue that has come to light since Mr. Tillotson has been on the case are some other documents that we were seeking with respect to financials. And when I spoke with Mr. Tillotson last week, he shared with me that the reason why his prior counsel, again, not Mr. Tillotson, but the prior counsel had not produced some of the other financial documents we were seeking was because they had them marked as privileged. We're talking about dollars and cents, nothing that has to do with attorney-client privilege. And Mr. Tillotson even acknowledged to me on the phone, look, I don't know why these were marked privileged. They should not be. I'm going to give them to you. So my concern is just that before Mr. Tillotson came in, the discovery has been completely and utterly mismanaged. There's no documents they haven't produced. 2 years into this, a major shareholder still doesn't have financial data from the company. And so what we're asking for is pretty narrow. We want an order granting a limited forensic review and an order compelling those discovery responses relating to the financials.
Mr. Tillotson.
Just take myself off mute. Yes, Your Honor, let me deal with those in two buckets. And Ms. Pettit's right, all this predates me, but I've tried to make a quick effort to solve these problems. I don't want to fight about discovery. We want to get to the merits. So first, the issue of the emails. As I understand the issue, there was 2 documents produced in the Delgado case that she says were not then produced in the 5-star case on it. That said, I have traced this back both to prior counsel who I replaced and the counsel before that, the Reese Marcado's firm. Everyone seems to think that whatever was done in Delgado was also done in 5-star. So no one has any explanation for why there might have been a document in Delgado not produced in 5-star. The best I can tell, there was no effort to withhold or not produce something. If there's anything, it was errant, because why would you produce?
Can I ask this, and maybe this is too simplistic, but can we just agree that any document used in Delgado can be used in 5-star?
Well, Your
Point
Honor,
number two, they agreed to that in April. So they agreed in an April 2021 email that anything in Delgado was produced in this case, anything in this case was produced in Delgado. So I believe immediately prior to me coming in, no one worried about what was produced in Delgado, not produced in Five Star, because they assumed that production now counted for both cases.
Your Honor,
So
may I respond briefly to just the facts there to make sure that it's clear?
Okay.
So the issue with that, Your Honor, is the timing. So in December of 2020, Five Star Global said that all responsive documents in the Five Star Global case had been produced. That's December of 2020. It wasn't until months later that there was any sort of agreement or that we got that in the global case. So that calls into question the entire amount of discovery that was done, because months earlier they said they'd given us everything. Now we have definitive proof that that absolutely was not the case.
right, but if I could finish. So the issue with what she wants, which is what Weekly Homes counsels you not to do, is to make us turn over all of our computers and servers to a third party and do some extensive forensic search. In Weekly Homes, they denied that, but they said in federal court, if you default on your discovery obligations as a last resort, that might be something you do. We clearly produced it. We just produced it in Delgado and not in this case. And then it was subsequently cured, if you will, with the April agreement that also predated me, where whatever was in Delgado was produced. So we produced that document, those emails, in this case in April of this year, effectively by their Rule 11 agreement. Now, the issue becomes, all right, and it looks to me like there was either an error or some inadvertence as to why it would be in one case and not another. If you're trying to withhold documents and not produce what she says are smoking guns, you wouldn't produce them in one case and not the other. That would only make things worse, not better. So the issue then becomes, all right, is there any other documents that might have been in Delgado that are not here? It wouldn't matter because she has the Delgado production, they're deemed produced. So then you default to the last question. All right, is there something that escaped Delgado and this case that's being withheld? Okay, so for that, she's given protocol, which I don't think you can do under Weekly Homes because it doesn't identify specific things you might be looking for that would be otherwise missing. She essentially wants us to redo a search for a 4-month period from emails, looking for any other copies of this email or documents, and then emails or documents that contain from or to Mr. Delgado that contain 5 words: termination, terminate, fire, transition, or executive summary. I'll tell the court to avoid a fight. I will represent to the court. We will go do that work. As the lawyers, we will go conduct that electronic search. The reason why we're better at it than sending it over to a forensic is A, we'll be faster. B, it avoids all the intrusion issues of Weekly Homes. And third, we can review because there might be an email that talks about terminate, that talks about a cleaning service or my cable or whatever. We're allowed to go through those and produce any responsive documents or withhold anything that would be privileged. So in short, Your Honor, I think that the issue, although I know it sounds good that there's somehow withholding of documents, it's not really very plausible because they were produced.
Can I ask a question? I want to make sure that, because I'm not exactly sure if I understand the difference between y'all's positions here. Is it correct, Mr. Tillotson, that everything that has or was ever produced in Delgado is considered produced in this case?
Yes, Your Honor, that is correct.
So even if it was produced before the agreement, after the agreement, anything that was at any time ever produced in Delgado is considered produced in this case as well.
That is correct. That is correct.
Then Ms. Pettit, what is maybe I don't quite understand the issue.
There is a huge missing link, Your Honor, a huge link. The author of this smoking gun email is Ed Delgado. The one email we have in the Delgado case where this email is being addressed is going from Mr. Baggett to third parties. That email had to get to Mr. Baggett. We know it. It would be impossible because Mr. Delgado within the metadata is listed as the author. So definitively, there are documents still today that have not been produced that are directly responsive to this and highly, highly relevant to the issue at hand. It would be impossible unless Mr. Baggett, I guess, had a jump drive in which he went on to Mr. Delgado's computer and hijacked all of his data, but there are absolutely missing documents. We have been raising this issue for an extended period of time. I've moved this hearing to accommodate.
So your issue isn't that it was produced in Delgado, not here, because that's been addressed. The issue is you think there's other emails out there. So like Mr. Tillotson was saying that it wasn't produced in either case.
Correct. And we know that happened.
Okay, so I get that a little more. I didn't understand that when you first said it. So Mr. Tillotson's proposal, which seems reasonable, is let him do the search and then produce it to you.
And I'm not opposed if we want to perhaps continue this portion of the hearing on the forensic review. I'm not opposed to continuing that. I trust that Mr. Tillotson is fully capable of running that. Predecessor counsel, clearly there were issues with that, so I would have been objecting more if it was his predecessor counsel, but I would agree to continue that portion of it based on his representation.
So Mr. Tillotson, I do want to make sure that if you are going to withhold documents like terminating the janitorial service or whatever, that you keep a privilege log that can be produced to Ms. Pettit about that, or some type of log that shows what you're withholding.
Well,
withholding log, I guess.
Of course, Your Honor, but first let me state, just so no one's misled, it will not be me doing it. They don't let me near electronic searches that way. So my team will do it. They're very skilled at it, but they will keep, if anything comes up with those search terms, and this is a fairly common process, you know this, they'll keep track of what it is and why they don't. They'll err on the side of production for those, and we'll do that search. So I'll commit to doing that search. I don't know the volume yet, Ms. Pettit, so I can't give you an exact date, but they'll get going on it this week, and we'll let you know.
What is this case set for trial?
February, Your Honor.
Yeah. So we'll have to do, you have to capture the data, then you got to run search, and you get so many hits. The more terms and the broader the terms, the more hits you have.
Is this case judge tried or jury, or do we already work that?
As to Mr. Tillotson's client and mine, it is going to be a bench trial. As to Southfield, that issue is set for hearing at a later date.
Okay, that's right.
So
okay, and so the second issue?
Yeah, so the second issue, the only problem I have, Your Honor, is that the requests, so the request number 187 to, what is it, Julie, Ms. Pettit, 216? 216 asks for specific, like, invoices and receipts for specific things, sales discounts, the amount of sales discounts, yearly memberships, and there's about 25 categories for it. And I don't know, because we haven't pulled the data, whether this is going to require a significant amount of work or whether this can be pulled through, single financial data that would show all of these items. So, there is at least initially a potentially a burdensome objection if I can't get a financial data sheet that would show all this. Imagine me saying, give me everything you spend on rent, on your car, on your insurance, on your groceries, on your club memberships, on your periodicals. That would be easy if you could just produce a page from QuickBook and show it. It would be hard if you didn't have it captured in that particular way. And I've not been able to determine whether or not we could produce.
So why don't you do this? If it's easy, produce it. If it's going to be burdensome, then give an estimate of the cost.
Okay, Your Honor.
Your Honor, just so it's clear, the records the requests are very narrow. I'm saying, give me that line item for the 2019 5-star conference. That's a 2-day event in September of 2019.
So this is just for 5-star conference?
Yes, just the 2019 5-star conference, extremely limited.
I recognize that. I just don't know the format, because sometimes the more specific you are, the harder it is to draw that data because it's not located in a certain part. But how about this, Your Honor? By Thursday, I'll respond whether or not it's easily producible, and if it's not, I'll confer with Ms. Pettit on and
Mr. Tillotson, this is no aspersion on you, but I will say that based on the history in this case, that the court will at least raise an eyebrow if there's some assertion that this is going to be, because it's just one conference. There should be one quick conference.
I understand, and I'm not suggesting to the court there's a lot of work. I'm just saying, given the way the data is asked for, it may be slightly more difficult, but I will make a good faith effort to figure it out.
And Ms. Pettit, obviously, if he's able to produce this in one big as one global spreadsheet, then he doesn't have to break it down into.
Yes, I would be thrilled if he could do that. That was my request that we made in 2019. So I would be thrilled for that.
And I don't know all the footsteps I'm walking in, but we have pledged to respond to these and get these done quickly. We reached resolution on the Whitley Penn documents today. We produced financials last week. So I'll work with Ms. Pettit, who I've known for a long time. We'll get it done.
Not that long.
I know. Sorry, Miss Pettit. I apologize.
Just kidding. So what else do we need to chat about? Are you going to get me an order on all this?
We will.
Yes, Your Honor, we'll do that.
We will. So, I know one other thing, Your Honor, we're working on a few scheduling items. I won't bore the court with it on it, but we may have a Rule 11 agreement regarding certain hearings or certain depositions. I'm hoping to reach an agreement on that quickly.
The court would love that. That would be great if you guys can work all this stuff out. And as much as I enjoy seeing you guys, it would be great that we didn't have to fight over the same thing over and over again. So that would be great. Is there hope with new counsel that maybe there's a chance this case could settle?
Always, Your Honor. Ms. Pettit and I have had some initial discussions. I'm working with my client. I'm new enough to the case to be optimistic, and I'm not, but I am working on that issue.
Yeah, we hope so, Your Honor.
Is it worth it to send you back to mediation, or is that premature?
Premature just now, Your Honor. I don't have a good enough, I haven't spent enough time with my clients to say a mediation would be useful, but maybe soon enough.
Okay. Just keep me updated. Good luck with everything, and you guys be safe. And let me know, when do we want to decide about the auditor? What is the next step in that? Do we want to have another status conference, maybe in 10 days or
I think
next
that'd
week?
be a great idea. I think a status conference.
Yeah, that's a good idea. That's a good idea.
When would you like it? Next Monday or next Friday?
Let's see.
It can't be this Friday, so next Monday or next Friday.
I think the 12th would work for us, Your Honor.
That's fine, Your Honor. That's fine.
The 12th is the funeral for Mr. Buchanan.
I'm sorry. Let's see.
So we need to kind of do it early in the morning. Not early, but like 9.
That's fine.
I think we have a hearing with you that may get moved. We have a hearing with you at 10 a.m. that morning on the 12th already. So that's why I had suggested that day.
Yeah, that works. Let's do 10 o'clock and we can just combine it together and we'll just do it. Status update on that. And if you do decide to that you want to use Mr. Smith, please email me together and I'll be glad to reach out to him and make sure that he doesn't have a conflict and stuff. I just don't know. I haven't talked to him about this particular one. I did talk to him about another case that Mr. Tillotson is familiar with about being the auditor in that case, but I haven't talked to him about this case. So I would want to talk to him before we made any final decisions.
Of course.
Okay.
All right. We'll see you in a bit and you guys be safe. Okay.
All right. Thanks, Judge.
Thank you, Your Honor. Appreciate it. Bye, Julie. Bye.
Bye.
All right. Is everyone here on the Carrera case?
Yes, Your Honor. James McCorkadale and Miss Carrera is here with me.
Mr. McCorkadale, we're currently on YouTube, which is kind of how they suggest we do it. This is, I don't know if there's anything highly private that you don't want to have on YouTube that's going to come up in this hearing. If you want me to turn off YouTube, I can, but it's kind of your call.
It can remain on YouTube. Anything that might otherwise be considered confidential is actually in the exhibits that we pre-submitted. And since those aren't going up on the screen, we should be in good shape.
Okay. Ms. Walker, are you ready to proceed?
Yes, Judge.
Let's go on the record on cause number DC 2017214, Carrera versus Escobar. Counsel, make your appearances.
Yeah, James McCorkadale on behalf of Plaintiff Erica Carrera.
All right, let's proceed.
Okay. We're here on a motion for entry of default judgment against the defendant, Jose Adelio Lozano Escobar. We have submitted to the court a series of exhibits A through N, as in Nancy, and we would ask that those be admitted at this time.
Ms. Walker, I don't know if Ms. Rieger has forwarded those to you, but A through N are admitted.
Okay. And then I think I also sent it directly to Ms. Rieger also. I hope I got the email right. So
Okay,
and then I've got my client here for some brief testimony about how the accident impacted her and would ask the court to go ahead and swear her in.
please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You may proceed.
Ms. Carrera, could you state your name for the record?
Erica Lynn Carrera.
And can you tell us a little bit about the accident that we're here on today?
Well, I was doing a delivery with my sister and that was it. We pulled into a apartment parking lot, and we were standing there. We were sitting still, and there was a gentleman that was in front of us. He started to back up, and we blew on the horn to get him to stop. He wouldn't stop, and he kept coming, and he then hit the front end of our car. I went forwards and my seatbelt locked. And so I ended up going to the emergency room because my back was hurt and my neck. And then I went to see a chiropractor for my back, and that I have problems with my discs. And I have to use a neck pillow and a back pillow and a brace. Pardon me. In order to sleep. I also have to use a walker because I get off balance because of my back. So I'm not able to work.
Are you currently taking any medications for your pain?
Yeah, I take gabapentin for my back, but it doesn't always help.
Have you continued to have pain since the time of the accident?
Yes, I have.
What impact has it had on your daily activities?
I can't walk that much without my back hurting. I do Grubhub, but I can't do it no more because I would be helping my husband picking up and delivering, and I can't do any of that anymore.
So before the accident, what type of work were you doing with your husband for Grubhub?
I was picking up the deliveries, and we were taking turns delivering and picking up. And now I can't even do that. He has to do it by himself. I can't even drive.
Have you been employed since the accident?
No,
Okay. At the time of the accident, how much were you making working for Grubhub?
well, we would make about anywhere from 150 to 200 a day, and we would do it 7 days a week.
And over the course of a year, about how much were you making?
Right off the top of my head, I'm not really for sure the exact amount.
Okay. Since the accident, you've not worked for Grubhub or anybody else?
No,
Okay. After the accident, did you go in and have any MRI imaging done of your spine?
yes, I did.
Okay. And did that imaging show that you had a herniated disc as a result of the accident?
Yes, it did.
Okay. Had you previously had any herniated disc in your back?
No, sir.
Okay. What, other than going to the initial emergency room and seeing the chiropractor, have you had any other form of continuing treatment?
I was going through physical therapy, but because my vehicle was damaged, I couldn't make it to the appointments, and they didn't have a way to get me there. So, but I did do some physical therapy.
And then, let's see what else. Has it had an impact on your ability to sleep?
Yes, it has.
And can you describe for us what that is, please?
I'll get like spasms in my neck and sometimes in my back, to where I have to go into the living room and sit in a straight chair. And I would have to sit there for a while to try to get it to subside so I could go lay back down. But I have to use a special pillow to sleep with that kind of sits me up.
Have you had any difficulties with your balance since the accident?
Yes, I have.
Can you describe those for us, please?
I can like stand up, and when I stand up, it like, I can't like get my balance under control to be able to walk. So that's why I have to use the walker.
Have you lost your balance and fallen since the accident?
Yes, I have.
On approximately how many occasions?
About 4 or 5.
Okay. And I think that's usually a surprise to you when that happens?
Yes.
Okay. On your ability to lift since the accident, can you describe for us, can you lift objects or move objects?
I can't lift probably more than maybe 1, maybe 2 pounds, even at that.
Okay. Has your medical condition remained basically the same since the accident?
Yeah, everything's the same except for when my back and what have you's more problems with it since the accident. But
Okay.
before the accident, I was okay.
Do you, in your observations, are the injuries and the difficulties you've sustained, are they chronic and will they continue into the future?
Yes, they will.
Okay. That's all we had, Your Honor, for the live testimony.
Okay, what are you requesting for past physical pain and suffering in this case? Actually, what's the total medical?
The total medical is in Exhibit N, which is a summary of the economic damages. The total medical is $15,230.77.
Okay,
The property damage is $1,013.24.
okay,
Then loss of wage earning capacity in the past since the time of the accident, we're asking for $50,000 there.
okay,
And then for loss of future wage earning capacity.
here, let's do this.
Let's do this.
Because this is the order you have it here. What are you asking for past pain and suffering?
Past pain and suffering would be $50,000, Your Honor.
Okay. Give me a second. It takes me a second to do this.
Sure.
Okay, future pain and suffering,
Future pain and suffering would be asking for 80, Your Honor.
80.
80,000, I'm sorry, yeah.
Okay. It seems a little high for 15 in meds, but. Okay, give me a second. This isn't working. Okay, you said past earning capacity 50,000.
Correct.
Okay, future earning capacity.
Future earning capacity, we think that 200 would be supported by the evidence. She is 47 years old. She planned to work to her normal Social Security retirement age of 67, which would have been an additional 20 years. And so the reduction in capacity over that 20 years gets us to that number.
Okay. Physical impairment.
I think physical impairment would be really up to the court's discretion at that number. I think some numbers such as around 25,000 would be appropriate there.
Sorry, I'm having some computer issues here. 20,000. All right, and then we have future physical impairment.
The same amount, 25,000, Your Honor.
And past medical, you said 15,000.
Let me get it in front of me.
Sorry, I had it written
Yeah.
down. $15,230.77.
Correct.
The cost of repairs is
1013.24.
okay. All right, the court will grant judgment as requested by the plaintiff. I'm going to go ahead and enter this in right now, and give me 1 second. 214. Okay. And you should be able to get this offline by tomorrow.
Correct.
If there's a problem, just call my court clerk.
Certainly.
I'm sending it to the workflow queue right now. Okay, well, it's good to see you. I'm sorry, Ms. Carrera, you went through all this. Sounds like it was a traumatic experience, and I wish you the very best of luck with your future.
Thank you.
All
May we
right.
be excused, Your Honor?
You may. You guys have a great day.
You
You
too.
too.
Thank you very much.
Mr. Bucati is not with this case, right? This Carrera case,
Yeah,
right?
Mr. Bucati, are you here for the 450? What are you here for, Mr. Bucati?
Can you hear me okay?
Yeah.
Okay, I'm here on the last case, which is the motion for summary judgment on DC-21-08963. C-Spine Sales versus PSN affiliates.
Give me 1 second. Okay. Let me pull this up. I don't think there was a response filed to this, correct?
That is correct, Your Honor, but I do want to make a statement on behalf of opposing counsel. He called me this morning. We have been friends for a long, long time, 30 years. He is not making an appearance today, and it is out of no disrespect to the court. He wanted me to make that announcement to the court. He will
I
not be
appreciate that. I really appreciate you telling me that. Is he doing okay?
He's doing fine.
Well, I'm sorry he couldn't make it today. Why don't you go ahead and just make a short presentation about what's going on, and we'll get this taken care of.
Yes, Your Honor. My name is Mark Bucati, and I'm the attorney of record for the plaintiff, C-Spine. I might have a little problem talking because I have temporary implants in right now. So in any event, I'm almost at the end. That's
Okay.
right. But in any event, I represent C-Spine Sales LLC. And this suit was brought against PSN Affiliates LLC and Group Surgical Partners Integrated LLC, doing business as Legion Outpatient Surgery Fresco. My client provided spinal implants to the named defendants for which they have not paid. So we filed suit, breach of contract, and mainly on sworn accounts. Now, an answer was filed, but only a general denial. There's no sworn denial on file. And as a matter of law, and I could cite to the court many cases, I don't think, if the court wants me to, I will.
I've dealt with this issue many times, so no worries.
Okay, in any event, so I filed motion for summary judgment for failure to follow the rules 193, 9310 and text rule subsector 185. So they cannot deny any of the items in the account. And I think that my client is entitled to a judgment as a matter of law. I've also filed an attorney's fees affidavit. So I'd ask the court to enter judgment in my client's favor in the principal amount due plus prejudgment interest at 6% per annum. And I do not multiply it. I don't compound it. I never do that. I just keep it at the bare minimum when I submit proposed judgments.
And that's contained within the judgment, correct?
Yes, Your Honor, that I filed on, I think it was on October 8th or so.
Yes.
And then I've also included an attorney's fees affidavit and that's included in that proposed final summary judgment.
Great. I'm just sending an email. Okay, well, I will go ahead and you should be able to get this offline by tomorrow. I just forwarded the summary judgment order to the clerk, so you should be able to get that tomorrow. And Mr. Bucati, it's so good to see you. I hope you're doing
Good to see
okay.
you.
Hope you overcome the implant issue, and you be